Hello, I am Dr. Rajshree Chatterjee, Associate Professor, Department of Journalism and Mass Communication, Jagannath University, Jaipur.
Today I am going to discuss Press and Registration of Book Act 1867. Section 1 Interpretation Clause. Book includes pamphlet in any language and every sheet of music, map, chart or plan separately printed. Editor means the person who controls the selection of the matter that is published in a newspaper. Magistrate means any person exercising the full power of a magistrate, and includes a magistrate of police. Newspaper means any printed periodical work containing public news or comments or public news. Paper means any document including a newspaper other than a book. Prescribed means any document including a paper other than a book. Prescribed means prescribed by rules made by central government under section 20A. Press registrar means the registrar of newspaper for India, appointed by the central government under section 19A, and includes any other person appointed by the central government to perform all or any other the functions of the press registrar. Includes styling and printing of lithography. Registrar means the registrar of newspaper, maintained under section 19B. Under section 3, which says that every book or paper printed within India shall have printed legibly on it the name of the printer and the place of printing, and the name of the publisher and the place of publication. Section 4 says, keeper of printing press to make declaration. That means no person shall within India keep in his possession any press for the printing of books or papers which shall not have made and subscribed the following declaration before the district, presidency of subdivisional magistrate within the local jurisdiction. As often as the place where a press is kept is changed, a new declaration shall be necessary. A statement relating to the change is furnished to the said magistrate within 24 hours thereof, and the keeper of the press continues to be the same. Rules as to publication of newspapers. Newspapers shall be published in India except in conformity with the rules hereinafter laid down. Without prejudice to the provision of section 3, every copy of every such newspaper shall contain the names of the owner and the editor thereof printed clearly on such copy, and also the date of its publication. The printer and the publisher of every such newspaper shall appear before a district, presidency, subdivisional magistrate, within whose local jurisdiction such newspapers shall be printed or published, or shall make and subscribe and duplicate the following declaration. And the last blank in the form of declaration shall be filled up with a true precise account of the premises where the printing or publication is conducted, shall specify the title of the newspaper, the language in which is to be published, and the periodicity of the publication. A new declaration shall have these necessary points if where the title of the newspaper or its language or the periodicity of its publication is changed. As often as the owner of newspaper is changed, as often the place of printing or publication is changed. It is very important that a statement related to the change is furnished to the said magistrate within 24 hours thereof. The printer or publisher, or the printer and publisher of the newspaper continues to be the same. Every declaration made in respect of a newspaper shall be void, and where the newspaper does not commence publication. Let's discuss the authentication of declaration. each of the two originals of their every declaration so made and subscribed as it aforesaid shall be authenticated by the signature and official seal of the magistrate. Any declaration is made and subscribed under Section 5 in respect of a newspaper. The declaration shall not, save in the case of newspapers owned by the same person, be so authenticated unless the magistrate. Deposit. One of the said originals shall be deposited among the record of the office of the magistrate, and the other shall be deposited among the records of the High Court of Judicature. Inspection and supply of copies. The office in charge of each original shall allow any person to inspect the original. On payment of a fee of 1 rupee shall given to any person applying to a copy of the said declaration, attested by the seal of court which has the custody of original, on payment of a fee of 2 rupees. According to section 11A and 11B, 11A says copies of newspapers printed in India to be delivered gratis to government. The printer of every newspaper in India, 2 copies of each such issue of such newspaper as soon as it is published, shall deliver free to expense of such officer as the state government may, by notification in the official gazette and to the government. Section 11B says that copies of newspapers to be delivered to press registrar. Under this act, the publisher of every newspaper in India shall deliver free to expense to the press registrar 1 copy of each issue of such newspaper as soon as it is published. Let's discuss the penalty for printing contrary to the rule in section 3. Whosoever shall print or publish any book or paper otherwise than in conformity with the rule contained in section 3 of this act shall, on conviction before a magistrate, be punished by fine not exceeding 2,000 rupees, or by simple imprisonment for a term not exceeding 6 months, or by both. Let's discuss the penalty for keeping press without making declaration required by section 4. Whoever shall keep in the possession any such press as aforesaid in contravention of any of the previous contained in section 4 of this act shall, on conviction before a magistrate, be punished by fine need exceeding 2,000 rupees, or by simple imprisonment for a term not exceeding 6 months, or by both. Let's discuss the punishment for making false statement. Any person who shall, in making any declaration or other statement, make a statement which is false, which he either knows or believes to be false, or does not believe to be true, shall, on conviction before a magistrate, be punished by fine not exceeding 2,000 rupees and imprisonment for a term not exceeding 6 months. Let's discuss the press registrar shall maintain the prescribed manner a registrar of newspaper. The registrar shall, as far as may be practicable, contain the following particulars about every newspaper published in India, namely, first, the title of the newspaper; second, the language in which the newspaper is published; next, the periodicity of the publication of the newspaper. Another point is the name of the editor, printer, and publisher of the newspaper, and the place of printing and publication. It is very important to note that every newspaper has to mention the average number of pages per week, the number of days of publication in the year, the average number of copies printed, the average number of copies sold, to the public, and the average number of copies distributed free to the public. The average being calculated with reference to such periods as may be prescribed. Retail selling price per copy. The name and addresses of the owners of the newspapers and such particulars relating to ownership as may be prescribed. And lastly, any other particulars which may be prescribed. Let's discuss the defects. The anomalies begin with the preamble of this Act itself. It says that the Act is for the regulation of printing presses and newspapers, for the prevention of copies of book and newspaper printed in India, for the registration of such books and newspapers. Around 133 years ago, there may have been little justification for a common legislation for books and newspapers. But today's condition, such clubbing together of newspapers and books is not possible because their needs are totally different. As for the preservation, in 1954, the National Libraries Act was passed. It was meant specifically for the delivery of books and newspapers to all the national libraries. Copies of books to be preserved is still understandable, but how is it necessary or even possible to preserve each and every copy of more than 40,000 newspapers in various languages in India? How will the funds and the space be provided for this exercise? If the task is impossible of performance, it should not be continued to remain in the Act. There is thus an urgent need to remove books from the purview of the Act, and also to remove the provision about preservation of copies of newspaper. The Press and Registration of Book Act lays down a time limit within which publication has to start after a declaration has been filed. But there is no time limit within which a declaration has to be filed after a clearance has been given by the press registrar. Also, few people file the declaration after publication of newspaper has ceased. Some publishers want to stick on to the title in the hope that someday they may again resume publication. The heirs hardly even bother to file a ceasing declaration. If a newspaper is running at a loss, which publisher has the time or money to file a ceasing declaration? Next, let's discuss that what are the points of suggestions by First Press Commission. The First Press Commission found it difficult to get figures on the press in India. It therefore suggested that there should be a registrar of newspaper whose duty should be to submit to the government a report every year on the press in India. There were to be the deputy registrars under the press registrar in every state. These deputies were never appointed. The press registrar was to submit his report on the basis of returns filed by newspapers. Only a small portion of the newspapers submit the annual report, since these includes all the big newspapers and most of the medium newspapers. The annual report of the press registrar may not be the 100% correct. It is very important to say that since these newspapers only include big newspapers and most of the medium newspapers, the annual report of the press registrar may not be 100% correct. Amendments to the Act made in 1960. Instead of solving problems, created new ones. The most important of these was that no officer could authenticate the declaration of printing a newspaper unless the press registrar gave the clearance. That the title of the proposed newspaper was not the same or similar to that of a newspaper published in the state, in any language or in the same language anywhere in India. District authorities all over India, from Kashmir in the north to Kerala in the south, had to consult the press registrar and find out whether the title proposed by the publisher was available. So, in this report, the Second Press Commission had made detailed recommendations about changes in this Act. A bill amending the Act in 1988 was introduced in Parliament. There was an outcry because the bill gave sweeping powers to the district authorities to enter the premises of a newspaper establishment. There was a fear that the magistrates and the police might misuse these powers. Before anything could be done to rectify these defects and to make the procedure for filing the declaration for a newspaper easier, and also to remove the anomalies in the Act and the bill, the Lok Sabha was dissolved. All these factors combined to create a situation where, within 20 years of amendments made in 1960, the press registrar had cleared more than 250,000 titles, but the number of newspapers actually being published did not go to more than 45,000. The other titles fell almost equally in three categories. The title had been cleared, but no declaration had been filed. A declaration had been filed, but the publication had not begun. Or third, publication had begun, but the publication had then ceased. The press registrar had no machinery under him to find out how many newspapers were actually being published in the country. The district authorities, before whom declarations were filed, were in no better situation. They had more important things to do than keeping an eye on the publication of newspapers. Efforts made by the press registrar to activate them through the chief secretaries also did not bring any results. It is to the credit of press registrar that by giving a public notice, as many as 1,70,000 out of 2,50,000 blocked titles had been unblocked and made available. The unblocking is being carried out on an continuing basis now. It was a regular complaint by prospective publishers that they had to approach the press registrar several times before they could get a clearance for a title. The prospective publisher was often told that the title he wanted was not available, but the press registrar was not able to say where, if at all, a newspaper was being published under the title. The unblocking of the titles has removed this irritant. It is very important to notice that by making those changes, the title registration has been made a little bit easier. Let's discuss the conclusion. While the press registrar was able to solve the problem of blocked titles by administrative action, another problem appeared, which was far more fundamental in nature. It is only if the owner is the same can two newspapers with the same title be published. But the courts have held that the right to publish a newspaper under a title is a right to property. It can therefore be transferred freely. How can anyone come in the way if a person published a newspaper permits another to bring out an edition from another center? During the last 40 years, such transfers have in fact taken place. The press registrar and the district authorities have been forced to accept the violations of the PRB Act. Then again, a person may be bringing out several editions of his newspaper and may say in his will that each of his sons will inherit one or more editions. They will bring out these editions under the same title. The owner would be different, and this will in violation of the Press and Registration of Book Act. But can any act interfere with the basic law of inheritance or transfer of property? It is therefore ridiculous to have such a provision which is in violation of basic law but is being infringed by the impunity. So, in this topic, we have discussed the Press and Registration of Book Act, the provisions, what are the flaws that are still continuing, the amendments that have made this act better, what are the problems that we are facing related to Press and Registration of Book Act in India, and lastly, that the conclusion that how things can be made better so that it may make things easier to understand Press and Registration of, and the function of Press and Registration of Book Act. The task of authentication of declaration should be taken away from the district authorities and to entrusted to the Press and Registrar and his deputies. The clause about preservation of copies of newspapers and the confusion about the publication of newspaper with the same and similar titles should be removed. And finally, in this age of laptop printing, should we still have a law for registering printing processes? Thank you.